The House of Open Voices was closed, while an old woman still had both hands on the witness board. Alda Merek sat beneath 12 silver bells, her swollen knuckles resting against polished oak. Winter fever had taken most of the sound from one ear and all from the other. For 3 mornings, she had pressed her testimony into the tuned surface while the board carried each rhythm through the floor to the court clerk's slate. On the 4th, Alpha King Osbert Shaw entered with royal guards and a closure decree. Chief Judge Livia Vaughan walked beside him in black judicial wool. The method permits interpreters to shape testimony before the court receives it. Assisted statements cannot remain valid until their reliability is reviewed. Mildred Crane stood between the guards and Alda's chair. Then review the boards. Do not erase the witnesses. The hall is being suspended, not destroyed. The seizure orders reopen when their testimony is suspended. Alda's orchard would return to a noble claimant by sunset if her assisted statement no longer counted. 27 elderly, injured, partially deaf, or speech-impaired wolves had cases resting inside the hall. Some might lose land. Others might lose pensions, custody claims, or the right to challenge guardians who spoke more smoothly than they could. Livia faced the judges. Traditional hearing law requires words given directly before the court. Here, pressure rhythms are translated by attendants, repeated through bells, and entered by clerks. Every layer creates opportunity for influence. The witness presses the board herself, Mildred said. The vocabulary is registered before testimony. The clerk records pressure, duration, and sequence before interpretation. And who trains the witness? I do. Who tunes the bells? I do. Who explains the pattern? I do. Livia's argument was not foolish. That made it dangerous. A corrupt keeper could lead a frightened witness, alter a tuning, or pretend an uncertain rhythm carried a clearer meaning than it did. Mildred had built safeguards for each risk. None appeared in the judicial summary Osbert held. Did you read the board calibration objections attached to Judge Vaughan's report? She asked. I read the certified findings. You once put your hand on a table to hear a man. Now you used a report to decide he had no voice. Something tightened beneath his left eye. Years earlier, before he became king, Osbert had sat at Mildred's kitchen table with her husband Gideon, who returned from war unable to hear spoken questions. Mildred taught the prince to place 2 fingers against the wood so Gideon could feel when a sentence began. Gideon later lost his home because a royal court called his testimony confused. Now Osbert held the decree that would make the same exclusion lawful across the pack. The House of Open Voices is closed pending Crown review, he said. Its assisted testimony is temporarily invalid. No apology softened the judgment. Mildred's authority seal was removed. Guards covered the vibration boards. One clerk reached for Alda's hands. Let her finish the pattern she began, Mildred said. The hall is closed, Livia replied. A sentence does not become corruption because a decree arrives before its ending. Alda looked from face to face. Unable to follow the spoken exchange, Mildred tapped the board's closing signal, hearing interrupted by outside authority. Alda lifted her hands. The gesture carried more humiliation than tears. She had come ready to answer questions. The court had chosen a method that made her silence look like absence. The royal clerk spoke from Osbert's right. Osbert looked first to the left. The mistake lasted 1 breath. Mildred noticed because she had spent years watching people hide where sound failed them. She gave him no mercy. You remember how Gideon answered you? His gaze cut toward her. You put your hand on the table because speech was not the only honest way to testify. This review concerns legal reliability. It concerns whose difficulty the law is willing to accommodate. Livia stepped between them. Personal history cannot govern evidence. No, but neither should judicial comfort. The guards sealed the main doors. Wax pressed into the hall's emblem, an open wolf's mouth beneath a crescent moon. Mildred surrendered the tuning hammers and turned toward the witness passage. Then the first moon-hearing bell rang. No hand touched it. A low silver note moved through the closed hall. A second answered. then a third. The floor beneath Alda's board brightened in pale lines, each glow following the pressure path her hands had made that morning. Residual vibration, Livia said. The boards were covered before the royal seal struck, Mildred replied. The bells continued. Long pressure. Too short. A weighted pause on the left edge. 3 rising strikes. Another pause. The sequence passed through 9 bells, stopped, then resumed with 7 beats the royal record did not contain. The clerk opened Alda's transcript. His face changed. What is missing? Osbert asked. The official record ends after the 3rd rising strike. Alda's hands had continued beyond it. The moon-hearing bells did not preserve identity, words, or legal meaning. They could not prove Alda's orchard claim, accuse a judge, or explain why the transcript stopped. They retained only the rhythm and pressure carried through the tuned board. Mildred stepped into the glowing pattern. The bells are not telling you what Alda said. They are telling you she had not finished when your record decided she was silent. Livia recovered first. A recording gap may be clerical error. Yes. Or a tuning fault. Yes. Then this proves no deliberate erasure. Not yet. Alda placed a wooden confirmation tile on the board. Every assisted witness used one after completing a disputed section. The tile carried her claw mark and the pressure count witnessed before court. 31 beats. The royal transcript contained 18. Osbert stared at the difference while the bells repeated the missing 13 across the courtroom floor. Mildred's hall remained closed. Her authority remained stripped. Alda's property seizure remained active. Osbert had allowed the bells to speak, but he had not yet restored the people whose voices his decree had suspended. But the judges could no longer claim the record ended where the witness did. As the final bell faded, a second row began to ring from the sealed archive wall. Note Alda's pattern. An older one. The exact pressure rhythm Gideon Crane had given in the hearing that cost him his home. The older pattern did not prove Gideon's claim was true. It proved only that the house had kept a rhythm the royal transcript no longer carried. The first thing Mildred did was cover Gideon's ringing pattern with witness cloth. Not because she feared it, but because grief could make an old injustice consume the living case before her. Alda Merek still sat beneath the silent bells. Her orchard seizure remained active, her hearing unfinished, and the royal transcript still stopped 13 beats before her confirmation tile said it should. Livia Vaughan watched the archive row fade beneath the cloth. Residual pressure proves only that a pattern once moved through the boards. It does not prove what the pattern meant, whether it was interpreted correctly, or whether the missing section had legal value. I agree, Mildred said, which is why we begin with Alda. Osbert did not apologize. He sealed the active board, the clerk's transcript, Alda's confirmation tile, the closure decree, and the cloth covering Gideon's older pattern under 5 separate witness marks. He left the House of Open Voices closed. Mildred's authority seal remained in royal custody. He had stopped the record from closing further, but not the seizure waiting behind it. Then he granted her temporary pressure rhythm witness, standing for Alda's testimony chain alone. She could examine the board record, the interpreter slate, the clerk's timing marks, and the confirmation tile. She could not reopen another case, restore assisted testimony across the pack, or resume command of the hall. The seizure order remains stayed only until this review ends, Livia said. A seizure clerk waited beside Alda's orchard file, with a red transfer ribbon already threaded through his fingers. Alda could not hear what he was waiting to do, but she knew the color of losing land. Then the review will show whether the court stopped hearing before Alda stopped speaking, Mildred replied. Alda could not follow the spoken exchange. Mildred placed a narrow witness board across her lap and tapped each condition slowly. One case only. No property decision yet. Pressure. Sequence under review. Alda pressed her thumb against the agreement mark. The board record was the cleanest piece of evidence. Each testimony pulse had left a shallow silver impression beneath the polished surface, visible only when moonlight crossed the grain at an angle. Mildred did not translate it into words. She counted duration, direction, force, and the pauses Alda had registered before the hearing began. 31 beats. The court clerk's transcript contained 18. Livia leaned over the page. A transcript records admissible testimony, not every physical movement. A witness may repeat, hesitate, or press without completing a recognized phrase. Then, the interpreter slate should show why 13 beats were excluded. The slate lay beneath the clerk's copy, still carrying chalk dust from the morning. The first 18 beats were grouped into registered phrases. After them, the interpreter had marked a weighted left-edge pause, followed by 7 short pulses and a closing confirmation pressure. Beside that sequence stood one note: uncertain ending omit pending clarity. Osbert read it twice. Who wrote this? The interpreter, Selwyn Baird, was brought from the lower archive. He was an elderly wolf, with a stiff right hand and a habit of watching mouths before answering. I marked the ending uncertain, he said. Alda changed pressure after the third rising strike. Did you ask her to repeat it? Mildred asked. I signaled for repetition. Alda shook her head before the words were interpreted. Mildred tapped the question onto the board. Did the interpreter request repetition after the disputed section? Alda pressed no. Selwyn's face tightened. She may not have felt the signal. Where did you place it? On the interpreter rail. The witness board was under active testimony. The rail signal does not cross until the witness lifts both hands. Alda had never lifted them. The closure decree interrupted her first. Livia folded her hands. That may be a procedural mistake, not deliberate suppression. Selwyn could have believed the signal was received. Yes, Mildred said, but the note says pending clarity. Nothing in the file shows that clarity was ever sought. The confirmation tile came next. Alda had pressed it after completing the disputed section on the previous hearing day. The tile carried her claw mark, the date, and a pressure count witnessed by a second clerk. 31. The tile did not prove the legal truth of the orchard claim. It proved Alda believed she had completed the full section and that the court had accepted a physical count longer than the transcript it later certified. Osbert looked toward Livia. Why was the transcript certified before the uncertainty was resolved? Because the disputed ending was not entered as reliable speech, she replied. The court may exclude unclear material. After giving the witness a chance to clarify, Mildred said, where does assisted hearing law require that? Mildred turned to the hall rules. The current statute was silent. The House's own safeguard code was not. Any pattern marked uncertain had to remain attached to the transcript until the witness repeated, confirmed, or withdrew it before 2 observers. Livia's gaze sharpened. An internal hall rule does not bind the royal court. No, but your certified finding accused the House of corrupting testimony, while your clerk used its method to remove a section without following even that method's safeguard. The distinction held the room still. Selwyn admitted he had expected a later clarification hearing. The closure decree arrived before it could occur. Yet the transcript had been certified that same morning as complete enough to reopen the orchard seizure. Who changed pending clarity into final omission? Osbert asked. The certification sheet bore the mark of a reviewing judge, not Livia's personal seal. The judge had relied on a standard notation attached to the interpreter slate. The notation read, uncertain assisted ending exclude from record unless independently audible. Alda had no independent audible speech. The rule made her access method conditional upon proving herself without it. Mildred felt the old wound beneath the wording before she saw the archive reference printed at the bottom. Template H17. Osbert followed her gaze. What is H17? The archive clerk opened the template register. H17 had first been created 16 years earlier for a war-deafened witness whose pressure testimony was considered incomplete because no spoken version could confirm it. The witness was Gideon Crane. Mildred left Gideon's name beneath witness cloth and asked for the oldest surviving version of H17. Alda Merek still sat beneath the silent bells with the red seizure ribbon waiting beside her orchard file. The clerk holding it had not moved, but the threat in his hands had not lessened. If the review ended against her, He would thread the ribbon through the transfer order, and the land her family had kept for 42 winters would pass beyond her reach. Livia Vaughn watched the archive clerks unlock the template chest. Independent audible confirmation exists to prevent interpreter fraud. A pressure pattern can be misread, prompted, or given meaning the witness never intended. The court cannot accept uncertainty merely because exclusion feels unkind. No, Mildred said, but it cannot cure uncertainty by pretending the witness stopped. Osbert granted her temporary standing to examine the history and use of H. 17 inches Alda's case. Nothing more. The House of Open Voices remained closed. Mildred's authority seal remained in royal custody, and the bells were covered so no retained rhythm could be mistaken for legal interpretation. He did not apologize. The oldest H. 17 sheet was thinner than the current form and written in the hand of a long-dead court reformer. Its title was not exclusion of uncertain assisted endings. It was preservation of unresolved pressure testimony. The original rule required every uncertain sequence to remain physically attached to the transcript until the witness could repeat, confirm, or withdraw it before two observers. The disputed section could not be treated as evidence until clarified, but neither could it be erased from the hearing chain. Mildred placed the old text beside Alda's slate. "Pending clarity," she said. "That was once an instruction to preserve." Livia read the page without flinching. "And it may have failed. Leaving disputed patterns attached to active files could invite later reinterpretation by interested keepers. Then the remedy would be stronger custody, not removal." The first revision came 11 years after H. 17 was created. It added separate storage for uncertain rhythm, a duplicate pressure count, and a requirement that the witness's confirmation tile remain sealed with the transcript. No House representative objected because two trained board keepers sat on that committee. The second revision came 5 years later. That was the version used against Alda. Preserve until clarified had become exclude unless independently audible. The requirement for two observers disappeared. The confirmation tile remained listed as a courtesy record rather than part of testimony custody. An interpreter could mark a sequence uncertain, and a reviewing judge could omit it without returning the witness to the board. "Who approved this version?" Osbert asked. The revision sheet named 7 judges, 2 royal clerks, and 1 advocate for noble estates. No keeper from the House of Open Voices had attended. No deaf, injured, elderly, or speech-impaired witness had been represented. Livia folded her hands. The committee reviewed evidentiary reliability, not social access. Those are not separate when the reliability rule requires a deaf woman to confirm herself through sound, Mildred said. Alda watched Mildred's hands on the narrow board placed across her lap. Mildred tapped the old rule first. Uncertain section kept. Then the new one. Uncertain section removed without return. Alda pressed hard enough to make the wood tremble. Not confusion. Anger. Mildred tapped one question. "Do you want the missing section kept with your record?" Alda pressed once, hard and clean. Yes. The current H. 17 had entered her case exactly as written. Selwyn Baird marked the ending uncertain. He expected a later clarification. The reviewing judge used the revised template to exclude the 13 beats unless independently audible. Then Osbert's closure decree ended the whole before any return session could occur. Selwyn stood near the archive rail, his stiff hand closed around his interpreter chalk. "I should have placed the disputed sequence under separate seal," he said. "Under the original safeguard, yes," Mildred replied. "I believed the later hearing would cure the omission, and the decree made later impossible." He looked toward Osbert, but Mildred did not let responsibility collapse onto one old interpreter. Selwyn had made a procedural mistake. H. 17 had turned that mistake into a final silence. Livia said, "The closure was issued because the Hall's safeguards were already under question. A suspended method cannot be used to validate itself." "No one is asking the House to declare Alda truthful," Mildred answered. "We are asking why the court certified her transcript as complete, while its own interpreter still called the ending unresolved." The certification page passed through 3 hands. Selwyn's note read pending clarity. The reviewing judge copied the H-17 exclusion line. The chief docket clerk marked the transcript sufficient for property decision. Livia's office approved the seizure calendar from that certified record. Her personal seal did not appear on Alda's omission. The chain reached her court without yet reaching her intent. Osbert read the dates. He had signed the closure decree 2 hours before Alda's scheduled clarification session. No packet placed that session before him. "You closed the room that could have completed the testimony," Mildred said. "I acted on the finding that the room itself was unreliable. You acted before preserving the living hearings inside it." His jaw tightened. The red ribbon remained waiting beside Alda's file. Osbert extended the stay on the Orchard transfer until the template review ended. He did not restore the whole, Mildred's authority, or Alda's full testimony. He prevented the seizure from moving while the court examined the rule that had made the missing beats disposable. He had delayed Alda's loss. He had not yet restored the method by which she could defend herself. The archive clerk brought the revision committee minutes. They did not mention Alda. They did not mention Livia. The current chief judge had been a junior magistrate when the second revision passed. The first page described complaints that uncertain assisted testimony delayed estate claims and complicated final judgments. The second recorded a request to make unresolved pressure legally absent unless spoken confirmation existed. The request did not bear Livia's personal mark. It came from the Central Judicial Office 5 days after Gideon Crane's hearing. The office was the same one Livia Vaughan now commanded. The path reached Livia's court. It had not yet reached Livia's intent. The revision request arrived tied to 3 estate complaints and 1 narrow strip of judicial correspondence. Mildred read the complaints before touching Gideon's name. Alda Merek remained at the witness table with her confirmation tile beneath one hand and the Orchard transfer file beneath the other. The seizure clerk still held the red ribbon, though Osbert's temporary stay kept him from threading it through the order. Alda could not hear the debate moving around her, but she watched every page that passed toward the judges. Livia Vaughan stood beside the Central Judicial Office chest. Institutional templates outlive individual judges. They exist because endless clarification can prevent final judgment. Property claims cannot remain suspended forever because an assisted ending may someday become clearer. "No," Mildred said, "but a court cannot call an ending endless when it closes the method that would complete it." Osbert widened Mildred's temporary standing to the revision request and the estate pressure file attached to H-17. Her authority over the house remained suspended. The bells stayed covered. Alda's orchard remained under stay, not restored. He did not apologize. The first complaint came from a coalition of noble estate advocates. It argued that unresolved assisted testimony delayed inheritance transfers, prevented winter leasing, and left contested orchards, mills, and pasture rights unusable for months. Several cases involved elderly witnesses whose hearings required repeated board sessions. The complaint did not name Alda. Her claimant's family, the House of Reth, appeared only in a broader category marked Delayed Estate Recovery Western Agricultural Claims. At the time of the complaint, Alda's orchard case had not yet begun. Livia placed one finger beneath the category. "That is not evidence the template was written for her." "No," Mildred said. "It shows the pressure existed before her case and later reached it." Alda tapped the witness board with 2 firm beats. Mildred looked down. The board phrase was one Alda had registered before her hearing. "Land waiting is not land abandoned." Mildred repeated the pressure pattern for the record without translating more than the registered meaning aloud. Alda pressed her confirmation tile once. She had not asked the court to let property drift without decision. She had asked to finish the section explaining why the orchard still belonged to her family. The revision request's first draft kept the original preservation rule. Uncertain pressure remained attached until clarification, while courts could issue temporary management orders to prevent damage to disputed land. No permanent transfer could occur until the witness confirmed, repeated, or withdrew the section. A later margin note crossed through that protection. Too burdensome for final property orders. The words had been written by a central judicial office clerk whose name had faded from the roster. Beside them, another hand proposed a simpler rule. One interpreter uncertainty mark would render the disputed pressure legally absent unless independently audible. Independent sound protects against an interpreter inventing meaning, Livia said. Without it, the court may never know whether the board pattern was understood correctly. Then require a second interpreter, a repeated board sequence, or a sealed confirmation tile, Mildred replied. Do not require a deaf witness to become audible before the law admits she finished. Alda's hands moved before the judges answered. 3 short presses, 1 long, a closing beat. Mildred checked the registered board vocabulary. The phrase meant, I can repeat now. Alda placed both hands flat against the board. The request carried through the floor. The covered bells trembled faintly but did not ring. Mildred did not allow a new testimony section to begin while the house remained closed. She entered Alda's request as proof that clarification was available and being withheld by the continuing suspension. Osbert watched Alda's hands. The stay remains until she is permitted to repeat under lawful safeguards. He has delayed the ribbon. Mildred tapped for Alda. He has not reopened the board. Alda's reply was one hard beat. She understood the difference. The custody chain showed that the estate complaints passed from noble advocates to the Central Judicial Office, then into a closed review group. No representative from the House of Open Voices attended. The group treated clarification time as a burden on final judgment but recorded no study of how often uncertain endings were later confirmed, withdrawn, or corrected. Selwyn Baird had interpreted 43 uncertain endings under the old rule. 31 were clarified on the next session. 7 were withdrawn by the witness. 5 remained unresolved. Under the revised H17, all 43 would have been absent unless the witness could produce independent speech. Livia's expression tightened. Historical outcomes do not eliminate the risk of keeper influence. No, they show that uncertainty often has an answer when the witness is allowed to return. The second estate complaint involved a mill transfer delayed by a witness whose injured jaw prevented clear speech. The claimant lost a season of profit before the witness withdrew one disputed phrase. The complaint called that delay proof that assisted testimony could be used strategically. The witness file showed no finding of manipulation. The noble advocate's frustration was real. The accusation of abuse was not established. Mildred kept the distinction intact. A difficult process can be exploited. That is reason to strengthen custody, not to make unresolved people legally silent. Osbert opened the revision request cover sheet. It sought authority to make uncertain pressure legally absent after one interpreter mark so that property orders could become final without repeated return hearings. The request cited one case as its central warning. Crane matter shows danger of indefinite assisted endings. Mildred's breath caught, but she kept her hand away from Gideon's covered pattern. Livia read the note carefully. That still does not prove his claim was true. No. Or that the office acted in bad faith. No. It may show only that his hearing exposed a procedural weakness. Then we check whether the process was actually allowed to finish. Gideon's old hearing calendar was brought from the archive. His disputed pressure section had been marked uncertain after the first session. A clarification date had already been assigned, with 2 observers and a second interpreter. The H17 revision request was filed 3 days before that clarification. The clerk's note calling Gideon's ending indefinite had been written while his next hearing was still waiting on the calendar. The court had begun redesigning assisted testimony around the danger of his unfinished words before it allowed him to finish them. The red ribbon beside Alda Merek's orchard file remained unthreaded when the archive bell announced Gideon Crane's cancelled clarification packet. Mildred did not remove the witness cloth from his retained rhythm. She placed Alda's confirmation tile on top of the live case instead, a reminder that one woman was still waiting to finish while the court examined how another witness had been denied that chance 16 years earlier. Livia Vaughn read the packet seal. A revision request filed before clarification does not prove the office intended to suppress Gideon. Institutions prepare new rules while cases are active. The hearing may still have failed for lawful reasons. Then the cancellation record will show them, Mildred said. Osbert extended her temporary standing to Gideon's scheduled clarification session, its cancellation, and the transfer order that followed. He did not reopen Gideon's property claim, restore Mildred's authority, or lift the closure of the House of Open Voices. Alda's orchard remained protected only by the temporary stay. No apology crossed the witness table. The packet contained a second interpreter assignment, 2 observer seals, Gideon's pressure count sheet, and a fresh confirmation tile. The court had not treated his ending as incapable of clarification. It had prepared the exact safeguards the original H-17 required. Selwyn Baird examined the old board notation. The first interpreter marked the final sequence uncertain because Gideon shifted from center pressure to the lower right corner. Was that shift registered? Mildred asked. The vocabulary sheet answered. Gideon had reserved the lower right corner for a named person reference. The mark did not identify the person by itself. A separate name tile had to be placed beside the board and confirmed before 2 witnesses. The clarification packet listed such a tile under sealed attachment. It was missing. Livia's gaze narrowed. A missing attachment after 16 years may be loss, not removal. Yes, Mildred said, so we follow its custody. The old docket showed Gideon's disputed section contained 26 pressure beats. The certified transcript stopped at 19. His first interpreter had written uncertain identity reference, clarify with second witness. The next session was scheduled for the 7th morning after his initial hearing. 3 days before that date, the Central Judicial Office filed the H-17 revision request. On the 6th evening, an interim instruction arrived. Unresolved pressure identity references could be excluded if the witness could not provide independent audible confirmation. Gideon had lost most of his hearing in war. Damage to his jaw made sustained speech painful and indistinct. The rule required him to confirm an assisted identity reference by the very method his injuries had made unreliable. Alda watched Mildred tap the sequence onto her lapboard. Hearing scheduled. Rule changed. Hearing cancelled. Alda pressed 2 questions. Did he ask to return? Did they let him? The request ledger showed that Gideon arrived before dawn on the scheduled day. He brought Mildred, his second interpreter, and the confirmation tile. The guard at the judicial annex refused them entry because the disputed ending had already been classified as legally absent. He stood outside with the means to clarify in his hands, Mildred said. Livia did not soften. The annex guard followed the interim rule. That does not establish the disputed reference was accurate. No, it establishes that the court called his ending indefinite after preventing the session that would have tested it. Osbert opened the property docket. Gideon's home transfer became final that afternoon. The noble claimant had already received provisional possession, but permanent title had been waiting on the unresolved testimony. The missing 7 beats had not been ruled false. They had been removed from the record that could delay final judgment. Alda's hand closed over her own confirmation tile. The red ribbon beside her file shifted when the seizure clerk changed his grip. Mildred placed 1 question on the board. Do you still request clarification before any orchard ruling? Alda pressed yes, then added the registered pattern for 2 observers. Her agency entered the record before anyone could describe her as merely protected by Mildred. Osbert extended the stay again. Her clarification will occur before any final transfer. He has promised a session. Mildred tapped for Alda. The house remains closed, and the method remains suspended. Alda answered, with a single measured beat. Not enough. The clarification cancellation bore the mark of the then presiding property judge. He had cited the interim H-17 instruction and certified Gideon's transcript complete without the final 7 beats. Was he part of the later revision committee? Osbert asked. The archive clerk checked the roster. Yes. Livia's voice remained controlled. Judges often revise rules after encountering procedural uncertainty. Participation does not prove fraud. Mildred agreed. The judge could have believed the ending unreliable and the new rule necessary. The sequence showed influence, not yet corruption. The court then opened the observer correspondence. One appointed witness had objected to cancellation, writing that Gideon's identity reference was repeatable and that the missing name tile had already been lodged with the judicial annex. His letter included the tile's custody number. The archive register showed it entered the annex before the interim rule took effect. 2 hours later, the tile was transferred to restricted judicial storage under a notation, "Inflammatory identification hold outside assisted record." "Who authorized the restriction?" Osbert asked. The signature line carried only an office cipher. "Not Livia's, not the presiding judge's." Mildred requested the cipher index. The archive clerk hesitated because the volume included protected judicial identities, but Osbert placed it under closed witness seal rather than public reading. The cipher belonged to a junior records magistrate assigned to the Central Judicial Office. Livia Vaughn had held that position 16 years earlier. The cipher connected her to the custody decision. It did not establish why she restricted the tile, whether she read the underlying testimony, or whether the identification was true. Mildred looked at Livia. "Did you handle Gideon's name tile?" "I handled hundreds of restricted attachments." "Do you remember his?" "No." The answer preserved a defense. The custody record preserved the question. Under witness seal, the missing tile was brought from restricted storage. Mildred did not turn it over. A name tile could identify whom Gideon meant to accuse, but it could not prove the accusation. Before it entered any hearing, Gideon's 7 missing beats had to be restored to their proper board sequence and reviewed under the safeguards denied to him. The tile's reverse carried one additional mark: the personal court seal of the judge who had cancelled Gideon's clarification and later helped rewrite H17. Mildred refused to turn the name tile until Alda Merek's request for clarification was entered beside the red orchard ribbon. Alda watched from the witness chair while the clerk pressed her chosen condition into the record. No historical review would be allowed to delay her living hearing beyond the current stay. She placed one hand over her confirmation tile and gave a clean, deliberate beat. "Proceed." Only then did Mildred return to Gideon Crane's sealed attachment. Livia Vaughn stood beneath the covered bells. A judge's seal on the reverse may mean authentication, custody, or restriction. It does not prove the judge named on the front was corrupt or that Gideon's accusation was true. "No," Mildred said. "It proves the court knew which name his unfinished sequence was meant to carry." Osbert extended her temporary standing to the custody of Gideon's identity tile, and the 7 pressure beats omitted from his transcript. The House of Open Voices remained closed. Mildred's authority seal remained in royal custody, and Alda's orchard had only a temporary stay. He did not apologize. The tile was turned beneath witness glass. Judge Edric Say. 16 years earlier, Say had presided over Gideon's property hearing. He had cancelled the clarification session, certified the shortened transcript, and later sat on the committee that changed H17 from preservation into exclusion. The name did not prove fraud. It proved Gideon had attempted to identify the judge whose ruling took his home. Livia read the old docket. Witnesses accuse judges when rulings go against them. That is precisely why inflammatory identifications require independent support. "Then support should have been tested," Mildred replied, "not removed before the witness returned." Gideon's registered vocabulary sheet was brought from the lower archive. Each assisted witness selected pressure phrases before testimony, so an interpreter could not invent language afterward. The 7 omitted beats matched one registered sequence, received private boundary paper after public record closed. The sequence did not establish that any paper was false, secret, or improper. Combined with the name tile, it showed what Gideon had tried to place before the court. Judge Say had received a boundary document after the public evidence period ended. Alda leaned toward her board. Mildred tapped the distinction slowly. "He named an act. The act is not yet proven." Alda answered with 2 measured beats. "Then look, The boundary file had survived because permanent land transfers required duplicate maps. The public copy showed Gideon's cottage and grazing strip inside the Crane holding. A later judicial copy moved the boundary 12 yards east, placing the cottage on the claimant's land. Both maps carried lawful survey marks. Only the later one carried Judge Say's acceptance seal. Livia's expression did not change. Survey corrections occur after hidden markers, flood shifts, and clerical mistakes are discovered. Was the correction disclosed to Gideon? Mildred asked. No notice appeared in the hearing file. Was he allowed to challenge it? No return session followed. Then the problem is not that a second map existed. It is that the judge accepted it after closing the record and excluded the testimony naming that act. The claimant's submission receipt had been filed 1 day after Gideon's first hearing and 4 days before his scheduled clarification. It described the new map as a recovered family survey. The submitting clerk was the claimant's cousin. That relationship created bias, not automatic falsity. The old survey master's ledger offered more. The seal number on the later map belonged to a plate reported cracked 2 winters before Gideon's case. A replacement plate had been issued, but the map carried the old impression. Osbert looked toward the archive master. Could a cracked plate still be used? Yes, poorly, or copied in wax. So the map may be false. It may, Mildred said. That still requires examination. Gideon's missing sequence proves he raised the custody problem before title became final. Osbert's gaze remained on the shortened transcript. He had once put his hand on Gideon's kitchen table and waited for meaning to reach him through wood. Years later, he had closed the only hole built to preserve that method. A clerk spoke from his right. Osbert turned first toward the left. The mistake was small. Mildred saw it. She placed a formal board between them rather than correcting him aloud. Question: will Alda's clarification occur before this historical review continues? Osbert read the pressure pattern through his fingertips. Yes. He reopened nothing beyond that promise. The hole remained suspended. 2 neutral interpreters were brought for Alda. Her board was recalibrated before witnesses, and the disputed 13 beats were preserved under separate seal. Because the house was still closed, she could repeat the rhythm for custody but not yet offer its legal meaning as completed testimony. Alda pressed all 31 beats again. The pattern matched the retained board record in duration, direction, and force. Selwyn Baird watched from the archive rail. I should have preserved it. You should have, Mildred said. The template taught you omission was safer than uncertainty. The repeat did not restore Alda's orchard. It established that clarification remained possible and that the closure decree, not her incapacity, had prevented it. Osbert extended the seizure stay until a lawful assisted hearing could be convened under 2 interpreters and independent calibration. He still did not restore Mildred's authority or reopen the house for the other suspended witnesses. The court returned to Gideon's tile. The restriction slip bearing Livia's junior cipher was unfolded beside it. Its public reason read inflammatory identification hold outside assisted record. A sealed underside contained a second note. Presiding judge named. Boundary paper challenged. Do not return tile until H17 revision is resolved. The handwriting belonged to Livia Varn. She had known whom Gideon accused and what record he challenged before his clarification date arrived. That did not prove she believed Judge Say guilty. It proved she helped keep Gideon from repeating the accusation in open court. Livia did not deny the note. She stood beneath the covered bells while the restriction slip lay between Gideon Crane's name tile and Judge Edric Say's altered boundary map. I kept an unverified accusation against a presiding judge from entering open record, she said. Assisted identity references could be influenced by interpreters or claimants desperate to delay judgment. Restriction was lawful. Temporary restriction, Mildred replied, until clarification. The rule was under revision, and you made revision a reason never to return the witness. Osbert granted Mildred temporary standing to examine the restriction decision and its effect on Gideon's scheduled clarification. He did not reopen Gideon's claim restore Mildred's authority, or lift the closure decree. Alda's orchard remained protected only by a temporary stay. He did not apologize. The memorandum named 3 risks: judicial intimidation, interpreter contamination, and indefinite property delay. None was invented. A false accusation could damage every ruling tied to a court. A suggestible interpreter could shape a name pattern. A claimant could prolong possession through uncertain testimony. But the memorandum offered no path back. No second interpreter, no fresh board, no independent name-tile custody. It converted caution into disappearance. Livia's gaze remained level. The office believed the accusation itself might contaminate clarification. Then appoint witnesses who never handled the claim, Mildred said. Instead, the accused judge certified the shorter transcript. Judge Say had approved the later boundary map, cancelled Gideon's return session, and certified the record without 7 disputed beats. Months later, he joined the committee that made such omissions easier. That sequence did not prove he forged the map. It proved every safeguard remained in the hands of the man being accused. Alda struck her board once. The registered phrase was simple: "My hearing now." The old woman had watched Gideon's dead case occupy the room long enough. Her orchard file still waited beside the red ribbon, and she had repeated all 31 beats before 2 neutral interpreters. Mildred faced Osbert. "She's ready." Livia objected. "The house remains closed because its reliability is under review." "Then hold the hearing in the royal court," Mildred said. "Use an independently tuned board, 2 interpreters, 3 clerks, and visible pressure counts. You would validate the method before review ends." "No, we would test whether access can survive review." Alda placed both palms against the wood. Osbert looked toward the clerk speaking on his right and answered the empty space to his left. This time the entire court saw it. His wolf rose beneath his skin in panic. Osbert turned toward the correct voice too late, one hand closing around the witness table. Mildred did not rescue him with a private correction. She slid a formal vibration board across the stone. "Use the method you suspended." Livia's face changed. "Your Majesty, this is unnecessary." "No," Osbert said. "It is overdue." He placed 2 fingers against the board. A siege blast had left one ear nearly useless, and the other unable to judge where sound began. He had hidden it because sovereign law treated unaided hearing as proof that an alpha could detect danger and deceit. Judges had begun standing on his stronger side. Certified summaries became easier than admitting he needed assistance. "You invalidated a method you use in secret," Mildred said. "I used no board in court. You arranged people around your injury. You called that ordinary because no one wrote the accommodation down." He accepted the strike without asking for softness. The public record entered his hearing loss and reliance on judicial summaries. It did not excuse the closure. It explained why Livia's findings reached him more easily than the objections beneath them. Osbert remained at the board while Alda's hearing was reconvened under temporary safeguards. 2 neutral interpreters sat apart. 3 clerks counted pressure independently. Mildred verified calibration and custody but could not interpret alone. Alda repeated the disputed 13 beats. The pattern matched her earlier record and confirmation tile. Only after the rhythm was secured did the registered vocabulary open. The missing section stated that the orchard claimant's boundary steward had moved 3 moonstones after Alda's husband died, then asked her to sign a maintenance paper she could not hear being read aloud. The statement was an allegation, not proof. Livia requested the paper and original survey. If the claim survives review, the transfer may still proceed. "Yes," Mildred said. "Now it will proceed after hearing her, not by defining unfinished testimony as absence." Alda's paper concerned irrigation repair. A folded page beneath it authorized boundary adjustment. No witness mark showed that the second page had been communicated through a board, interpreter, or readable copy. The claimant's steward could still argue Alda understood it. The court required his testimony and suspended permanent transfer pending review. The red ribbon was removed from the clerk's fingers. Alda's orchard had not been restored. Her voice had been restored to the case. Osbert looked toward Mildred through the board. Reopen the house under these safeguards. No. One successful hearing does not repair the decree that suspended 27 people without preserving their testimony. I will not return, while access remains a favor granted case by case. What do you require? A public inventory of every assisted case affected by H17, preservation of every unresolved sequence, and a rule that uncertainty remains attached until the witness confirms, repeats, or withdraws it. Livia said, that could reopen years of settled judgments. Only those where testimony was made legally absent by the revised template. Each claim must still be proved. The archive clerk brought the H17 usage register. 46 hearings had used the exclusion rule since Gideon's case. Beside 14 stood Edric Say's review mark. Beside 9 of those 14 appeared a junior custody cipher. Livia Varnes. Before the court could adjourn, Mildred ordered the H17 usage register copied under 3 seals. One remained with the Royal Archive. One went to the neutral clerks. The third stayed on the witness table beneath Alda Merek's confirmation tile. 46 assisted hearings had used the exclusion rule since Gideon Crane's case. Mildred would not allow the list to pass through another private office before the people inside it knew their testimony had been shortened. Livia Varn objected. Those files contain protected identities, family disputes, medical limitations, and accusations never admitted into evidence. Then protect the witnesses, Mildred said, not the fact that their endings disappeared. Osbert authorized a sealed inventory. He did not reopen every judgment, restore Mildred's authority, or lift the closure of the House of Open Voices. He ordered only that every omitted pressure sequence, confirmation tile, interpreter note, and final ruling be preserved. The covered moon hearing bells remained silent. Alda tapped the board on her lap. 1 short beat, then 2 firm. Count the people, not only the files. Mildred entered the instruction into the record. The inventory showed that H17 had reached more than land claims. 11 cases concerned property, 8 involved soldiers' pensions, 6 concerned guardianship over elderly wolves, 5 challenged debt transfers, and the rest involved inheritance, burial rights, marriage settlements, and testimony against pack officers. The revised template had entered every place where a witness required more time, touch, repetition, or visible confirmation than a spoken hearing allowed. Livia stood beside the register. That distribution proves the rule was general, not designed for one noble interest. It proves the harm was general. We still have to ask how the rule was used. The 9 files bearing Livia's junior custody cipher were opened by date, not outcome. In each, an interpreter had marked a final sequence uncertain. In each, disputed pressure was removed from the certified transcript, but the cases did not all favor nobles, and 2 ended without property transfer. The pattern was not simple enough to convict her. Mildred read the restriction reasons: inflammatory identification, unverified official conduct, risk of institutional harm, potential delay to settled authority. None described pressure quality, calibration, or interpreter disagreement. They described what the missing testimony might do if it returned. You were not restricting rhythms because they were technically unclear, Mildred said. You were restricting them because they challenged someone with power. Livia remained controlled. An accusation against an officer can destabilize a hearing before its reliability is established. Custody restrictions prevent rumor from becoming judgment. Temporary restrictions can do that. Yours had no return date. Osbert opened the first file. A war widow had challenged the pension officer who recorded her husband as deserting after death. Her omitted ending named a transport clerk. The identity tile was restricted under Livia's cipher, and the pension denial became final 2 days later. The file did not prove the clerk falsified anything. It proved the widow was never allowed to complete the accusation. A second case involved an elderly wolf whose nephew sought guardianship over his mill. His omitted sequence alleged that the nephew removed account stones before the hearing. The court excluded the ending. then granted the nephew control. Again, the allegation remained unproved because the witness was not returned to the board. You are presenting unresolved accusations as though repetition would make them true, Livia said. No, I am showing that your office made resolution impossible, then treated impossibility as absence. Osbert's hand rested on the formal board between him and Mildred. He read the registered pressure as the clerks entered it. Restricted without return, certified without completion. The act exposed his dependence before judges who had once arranged themselves around his stronger ear. I will no longer receive certified findings without attached objections, unresolved sequences, and custody notes, he said. That protects what reaches you next, Mildred replied. It does not repair what you signed before. No, the word was not an apology. It was the first time he accepted the boundary without defending his intention. Of the 9 files carrying Livia's cipher, 7 had been reviewed by Judge Edric Say. 6 became final within 3 days of the disputed ending being removed. 4 involved documents accepted after the public evidence period closed. The repeated procedure was visible. A witness named an official act. The identity attachment was restricted. The shortened transcript was certified. Final judgment followed before clarification. Still, the chain did not prove every accusation true or show that Livia and Say acted together for profit. Then the archive clerks found the return slips. Restricted attachments were supposed to carry a reconsideration date. 8 of the 9 slips had blank return lines. Gideon's carried a date scraped away. Under angled moonlight, the parchment showed the pressure of missing ink. The date had originally matched Gideon's scheduled clarification hearing. A scraped date may be clerical correction, Livia said. It may, so we test the ink and the hand. The royal document keeper compared the remaining strokes with the cancellation order. The ink came from the same iron batch used in Say's chambers. The scraping tool had a crescent notch matching a judicial seal knife logged to his office. That connected the alteration to Say's chamber equipment, not yet to his own hand. Osbert ordered the knife, ink ledger, and return slip register sealed. Alda pressed her board again. What happens to the people while you test old ink? Osbert ordered immediate preservation hearings for every living witness affected by H17. No underlying claim would be granted, denied, or reversed without separate evidence. The house remained closed, but neutral boards would be installed in the royal court until access law was repaired. Mildred did not thank him. You are building temporary doors because you closed the permanent one. I know. The answer passed through the board beneath his fingers. At the bottom of Gideon's return slip, the document keeper uncovered a second indentation beneath the scraped date. A routing mark. It directed the restricted tile from Livia's custody desk to Judge Say's private chamber on the night before Gideon was denied entry. The mark bore both their office ciphers. By dawn, the private chamber once assigned to Judge Edric Say had been sealed against every court officer, including Livia Vaughn. Say had trained half the senior judiciary, approved 3 succession settlements, and shaped Western property law. Opening his chamber meant admitting that the crown's stability might have rested on hearings shortened for convenience. Mildred entered beside Alda Merek, not behind the king. Alda carried her confirmation tile in one hand. The orchard file rested beneath her other arm, its red transfer ribbon removed but still tied to the cover as evidence of how near the seizure had come. She pressed one phrase into the portable board before taking her seat. Do not make the old dead more important than the living waiting. Mildred entered the instruction first. Livia stood under guard but not in chains. 2 office ciphers on a routing mark prove transfer between desks. They do not prove an agreement to suppress testimony. No, Mildred said, so we open what the transfer delivered. Osbert granted her temporary custody review standing over Say's chamber register, the H17 restricted attachments, and the seizure calendar linked to those files. He still did not restore the House of Open Voices or Mildred's authority. Neutral boards remained in the royal court for preservation hearings only. The first chamber ledger recorded Gideon Crane's name tile arriving the night before his clarification date. Say acknowledged receipt with his seal. Beneath it, Livia's junior cipher confirmed that the attachment was to remain outside the assisted record until H17 revision was settled. The next entry ordered Gideon's property judgment finalized at noon. Livia's defense remained possible. The identity tile accused the presiding judge. Removing it from his active hearing prevented contamination while another authority reviewed it. Which authority? Mildred asked. No reassignment appeared. No independent judge received the tile. No review date replaced the one scraped from the return slip. The attachment remained in Sayer's own chamber, while Sayer finalized the property transfer. The custody safeguard had placed the accusation in the possession of the accused. Alda pressed once against her board. Not safety. Mildred repeated the registered phrase for the record. The chamber register then opened the 8 other cases carrying both Say's review mark and Livia's custody cipher. In 6, noble advocates had filed urgency petitions before the witnesses' clarification date. The petitions cited winter losses, idle land, delayed rents, or uncertainty among heirs. None was unlawful. Courts often considered harm caused by delay. But attached to 5 petitions was the same private instruction. Final judgment may proceed once disputed. Assisted ending is rendered absent under H17. The instruction bore Livia's hand. She did not deny it. I believed unresolved accusations against officers and estate stewards were being used to prevent final orders, she said. The kingdom had emerged from 3 years of border fracture. Land could not remain leaderless while every uncertain rhythm produced another hearing. Then why were the endings not preserved for later review? Mildred asked. Because preservation kept them alive as rumor, as testimony awaiting examination, as danger, Livia said, and for the first time the word carried something more than legal control. You think courts survive merely by being fair. They also survive by being believed. A judge accused through a method no ordinary court could verify could lose authority before truth was established. Pacts tear apart when every ruling becomes provisional. Mildred understood the fear. She did not accept the remedy. You protected confidence by preventing the injured from completing the accusation. I protected finality. You made finality depend on who could speak in the form power preferred. Osbert read the exchange through the board beneath his fingertips. Every judge could see the king using the same kind of assistance his decree had invalidated. The chamber ledger did not show bribes paid to Livia. It did not show that every noble claim was false. It did not prove the omitted witnesses told the truth. It showed that she knowingly used H17 to make unresolved assisted testimony legally absent, so judgments involving powerful officials and estate interests could become final before clarification. Alda pushed her orchard file forward. Her claimant, House Rath, had sent an urgency petition 2 days before Osbert closed the House of Open Voices. It argued that another winter without permanent title would damage the trees and reduce pack revenue. A handwritten routing note directed the petition to Livia's review desk. The note read, "Assisted ending already uncertain. Closure will permit final transfer without return hearing." The handwriting belonged to Livia's chief docket clerk. Her approval mark stood beneath it. Livia looked at Alda rather than Mildred. I approved an administrative consequence of a lawful closure. I did not know what her missing beats alleged. That is the point, Mildred said. You approved losing them before knowing. Alda placed both hands on the board. The pressure traveled cleanly across the royal floor. You were willing not to know. No bell translated it. The meaning came from a phrase Alda had registered before testimony, confirmed by 2 interpreters and repeated by 3 clerks. Osbert ordered the clerk, the petition, and the routing ledger sealed. He suspended Livia from directing assisted testimony cases pending judgment. He did not declare her guilty of falsifying Alda's orchard claim or conspiring in every disputed transfer. Then he placed his own closure decree beside her approval mark. My order created the conditions she used, he said. I invalidated the method before preserving active testimony. I reopened seizures on certified summaries I had not tested against the witness records beneath them. It was a public admission, not yet repair. Mildred did not release him from it. Then your judgment must bind the crown as well as the judge. It will. The final chamber drawer held no gold or purchased rulings. It contained a policy memorandum drafted by Livia after Gideon's hearing and approved by Say. Its last instruction was precise. When assisted testimony threatens confidence in a sitting judge, senior officer, or settled estate, uncertainty shall be resolved in favor of institutional finality before the witness is returned. Below the sentence, Say had written one amendment. Apply through H17. Do not preserve the excluded rhythm with the certified record. Livia had signed beneath it. Mildred looked toward the 46 names waiting under seal. The court no longer faced a flawed template that had merely drifted into cruelty. It faced a policy designed to make certain unfinished voices disappear before anyone was required to hear what they challenged. By sunrise, every red transfer ribbon tied to an H17 case had been removed from the seizure desk and placed beneath witness seal. The ribbons did not mean the underlying claims were false. They meant no final transfer could proceed while a shortened assisted record remained unexamined. 46 cases waited in separate bundles for individual review rather than automatic reversal. Mildred Crane stood at the center of the royal court with Alda Merek beside her. The House of Open Voices was still closed. Livia Vaughn faced the judges without her chief seal. She had not confessed to forging maps, buying rulings, or inventing every noble claim. The evidence established something narrower and deliberate. She had helped design and apply a policy that removed unresolved assisted testimony when it threatened judicial authority, senior officers, or final property orders. I believed the court would fracture if every accusation against power remained alive, Livia said. I chose finality. You chose which voices finality could bury, Mildred replied. The royal panel convicted Livia of unlawful suppression of witness material, abuse of custody authority, and certification interference. It did not convict her of falsifying every claim touched by H17. Those cases would rise or fall on their own evidence. Judge Edric Say's surviving honors were stripped from the judicial archive. Every ruling connected to altered maps, restricted identity tiles, or omitted assisted endings was referred to independent review. Selwyn Baird received formal correction for failing to preserve Alda's disputed sequence under separate seal. He was not dismissed. The record acknowledged that he had expected clarification and that the revised template had trained interpreters to treat omission as safer than uncertainty. Then Osbert placed his closure decree on the witness table. He did not remain on the throne. My order suspended 27 living testimonies without preserving their active sequences, he said. I relied on certified findings while refusing the objections attached beneath them. I reopened seizures against people whose access method I had invalidated, while hiding that I also depended upon accommodation to hear this court. He placed 2 fingers against the formal board so his words entered both sound and pressure. My injury did not make that decision innocent. My fear of appearing unfit made me easier to govern through conclusions. Mildred did not tell him the admission was enough. It was not. The new hearing law was read before the court. No assisted method could be suspended without first preserving every active sequence, interpreter note, calibration record, and confirmation tile. Any uncertain ending had to remain attached until the witness confirmed, repeated, or withdrew it. Independent, audible speech could support a record, but could never be required from a witness whose lawful access method existed because speech or hearing was impaired. 2 interpreters would review disputed identity references. Calibration would be witnessed by neutral clerks. Custody restrictions required written reasons, a return date, and review outside the challenged authority. The House of Open Voices would reopen under those safeguards. Osbert brought Mildred's authority seal from royal custody. She did not take it from his hand. Place it on the witness table, she said. He obeyed. Mildred turned to the excluded witnesses gathered beneath the gallery. This office does not return because a king regrets closing it. It returns because the law now prevents one decree from making unfinished people disappear. Alda pressed approval into her board. Only then did Mildred take the seal. Her first act as restored keeper was to reconvene Alda's orchard hearing. The boundary steward testified that he had added the folded adjustment page to the irrigation paper. He claimed Alda understood the change. The court found no board interpretation, readable copy, witness mark, or separate consent attached to it. Surveyors examined the 3 moonstones and found fresh tool cuts beneath old moss, consistent with later movement. The evidence supported Alda's account. House Reth's transfer claim was denied. The orchard remained hers, and the court ordered restitution for income lost while the seizure proceeded on an incomplete record. Alda did not bow to the throne. She placed both hands on her board and pressed one phrase. "I was not difficult to hear. You were willing to stop." The words entered the new record. Gideon's case opened next, but not as a restored victory. The old boundary map, cracked survey seal, name tile, and omitted 7 beats justified a new hearing. Mildred entered his testimony as unfinished evidence requiring independent examination. His home could not be returned to a dead man, and the current occupants could not be displaced without review. What the court restored first was the fact that Gideon had spoken, identified an official act, and been denied the session meant to test it. His name was removed from the notation confused claimant. It was replaced with hearing unlawfully curtailed. That evening, the moon hearing bells were uncovered. They rang only when Mildred tested the boards, answering pressure with silver resonance. They named no guilty person. They translated no hidden truth. They preserved the shape of what had been given to them. Osbert came after the witnesses had gone. He wore no crown and brought no decree. He stopped outside the open threshold. Mildred placed a small board between them. He touched it first. "May I enter?" She pressed her answer, as a man willing to listen, not as a king expecting forgiveness. He crossed the threshold and stood where Gideon had once taught him that hearing could travel through wood. "I remembered that lesson," Osbert said. "I failed to let it govern me. Yes, I will not ask you to trust the confession more than the repair." "Good." His hand remained on the board, close to hers but not touching. Months of review still waited. 46 files would not become justice in a single night. The people harmed beneath Livia's policy still required patient hearings, evidence, and lawful judgment. Osbert pressed one final question. "May I remain while you work?" Mildred looked at the reopened doors, Alda's cleared orchard file, and Gideon's testimony restored to the place where examination could finally begin. Then she placed her hand beside his on the board. "You may remain," she said, "if you understand that listening is not the same as being forgiven." The moon-hearing bells stayed silent. They had no testimony to preserve. For the first time, Osbert listened without asking the law, the bells, or the widow to make his answer easier.